All right, welcome back, Civics students. I hope you had a great spring break as best we can during the coronavirus. This is Palm Sunday, so I hope you had a great Palm Sunday. Hopefully, you were able to at least watch Mass today. And looking forward to this week. Obviously, this is Holy Week, but we got some interesting things to talk about in terms of civics. So let me let you know the game plan for the rest of the week. Today, we're going to have two lectures, just like we normally would on Monday. The first one's going to be a quick history of judicial review and the Supreme Court, the different eras that characterize the court. And then the second lecture for today, we're going to be looking at the judicial process, how the Supreme Court makes its decisions, talking about the structure of the federal court system, topics of that nature. We don't have class on Tuesday. On Wednesday, we'll have one more lecture on the judiciary, and that's where we'll look at rival theories of constitutional interpretation, and then also the confirmation process for federal and particularly Supreme Court justices that have become quite contentious over the last really probably 20 to 30 years. And then on Thursday, we're going to be doing a new wrinkle in our online learning. We're going to have a live session. This is going to happen every week now. The last session of any class that you have will be a live session. That there will be no new instruction going on, and so this is an opportunity to ask questions, to review particular concepts, themes, points that we've made, and then also a chance just to see each other, have some accountability in terms of the work. And so that's going to happen on Thursday. And on Thursday, I will then post a take-home test that will ask you to answer questions on Congress, presidency, and Supreme Court. And that will be due the following Wednesday. We'll have no class on Friday. That's Good Friday, and no lectures on Monday, which is Easter Monday. And so we'll be back at it on Wednesday of after Easter, and that's when your take-home test will begin, and then we'll dive into some other topics. Okay, so that's the game plan for this week and really into the beginning of next week. I want to encourage you to watch these lectures, not to fast forward them. I've heard that some rumors that people are putting the fast forward button on or not even watching them at all. I encourage you to do that because your homework portion of your grade, which is going to be increasing because of the fact that we don't have a lot of discussion now, homework is going to be a greater proportion of your grade. And it's really about watching, for me at least, watching these lectures and listening to them. And we don't really have a primary text for this class. It was always going to be lectures from me. So you really got to watch them. You got to take notes on them, and you got to answer the questions that I provide you on RenWeb. So let's not cheat ourselves for the rest of the year. We're going to be doing this until May, and so until the end of May, and so we need to do this right. Okay, so we're going to be talking about the court. We've looked at the first two branches of government, how Congress operates, how the presidency operates, and now the other the last of the big three, so to speak. These are governmental institutions of the national government. And so the Supreme Court is the topic for today. And really the first topic that I want to, and I've taken a picture of my whiteboard. That's something that you should always be taking a look at so it can help you guide what we're going to be talking about for this online lecture. So the first topic is I want to talk about the dramatic power of American courts. There's on your Google form assignment, there's a couple of quotes. The first one is from Tocqueville, and to paraphrase it roughly, is that he basically says that there are no more powerful courts on the face of the earth than American courts. And the reason for that is that unlike most, especially when he was writing, and he's really looking at Europe at this point, most of the courts, obviously, they would play a fundamental role in adjudicating disputes between private citizens and all of that. But the idea that you would have a co-equal branch of government, the courts, that would be able to strike down or to check the power of a legislature or an executive, or maybe he would be thinking even like a monarchy, a king or something like that, was very, very novel. The idea that a judge could basically stand in the way between a law either being allowed to continue or not. And so this power of, and we're going to be using it a lot, judicial review, with the capacity of a court to strike down, to modify, to bring further meaning to the language of a particular statute. And it's not just legislative action, right? It's also what executives do, what presidents do, and also, because we have a federal system, a lot of the examples of judicial review have been the federal courts ruling on the legitimacy, the constitutionality, and also just the meaning of state statutes, state practices that that hinge upon federal power. And we're going to be going through a lot about how the federal courts work, and because it's the national or federal courts, it goes without saying that they don't have the authority to rule on matters that don't involve federal or national law. If it's a state matter or a local matter and has nothing to do with the U.S. Constitution or a federal statute or a practice of a bureaucratic agency at the national level, the court can't touch it. So that's important to note. But if they can, the court has this tremendous power of judicial review. And Tocqueville, for one, was kind of in awe of it. More on Tocqueville in a moment. But the other quote that I have on the Google form is from Hamilton, and this is from Federalist number 78. So let me read you a little bit of this. Of course, the Federalist Papers was a justification of the new Constitution, and here he's trying to persuade the critics of the Constitution that the federal courts actually should be given this kind of co-equal status. And the Anti-Federalists had criticized the court for being this, this body that there was no appeal from, that there was no way to actually counteract the rulings of the federal courts, in particular the Supreme Court. And so here's Hamilton trying to defend the legitimacy of the court. He says, "Whoever attentively considers the different departments or branches of power must perceive that in a government in which they are separated from each other," meaning separation of powers, "the judiciary, from the very nature of its function, will always be the least dangerous to the political rights of the Constitution." Right? So it's the least dangerous branch, according to Hamilton. He goes on and he says that they don't have the power of the purse, which is the power of Congress to tax and spend. They don't have the power of the sword, which is the executive branch, the commander-in-chief, and also the ability to carry out law. And this is a very important, actually, check on the judiciary itself, that even if the Supreme Court makes a ruling on a particular case, it's up to the elected branches of government, not the court, to actually carry that through. And so he continues, he says, on the contrary, the judiciary has no influence over the sword of the purse, no direction either of the strength or the wealth of the society, and can take no active resolution whatever. It may be truly said to have neither force, nor will, but merely judgment, and must ultimately depend upon the aid of the executive arm, even for the efficacy of its judgments. So the first argument that Hamilton makes is that don't worry, it's not going to be very powerful because it's got to depend on the other branches of government, and really all it has is its judgment and ruling on cases. And then then he has to, in some ways, justify this power of judicial review. And remember, in Article 3, there's nothing that says explicitly that the court has this power. it's an implied power. And I for one, I like to read the Constitution carefully and pretty narrowly. But it's hard, even for someone who is a strict constructionist, to disagree with this broad notion that the court, by hearing cases that are brought before it, either stemming from the Constitution or a statute that Congress has made with the signature of the president, that it doesn't have that authority when it rules on a matter, whether the law is valid or not, or if it's not dealing with a constitutional matter, what does the actual language of a statute actually mean? That's what we mean by statutory construction. So in both of these cases, he says that it is far more rational to suppose that the courts were designed to be an intermediate body between the people and the legislature. And so this is one of the other arguments about the court, that it's designed to be a check on the majority, a check on democracy itself. And we saw that before with the president, of course, not being elected directly through the Electoral College. We also see it with an indirect election of the U.S. senators. Now, we've also noticed that those branches of government have become more democratic over time. But the court, particularly because it's an appointed branch, and because of the nature of its interpretive powers, it really is designed to be out of direct politics. Now, we're gonna discuss the fact that in order to get on the court, members of the Supreme Court and the lower courts, these people, men and women, have to have they're politicians. They are involved in the political process. But once they get on the court, they have lifetime appointments at the federal level, and that gives them the ability to, maybe take on a difficult issue without being fearful of reprisal. So he says that it's an intermediate body between the people and the legislature. And Hamilton and other founding fathers were also very concerned that the most powerful branch would be the legislative branch. And that's where you'd find majority tyranny. Madison talks about this in Federalist Number 10. And so this idea that you needed these buffers between the people and their institutions of government is an important one. He says that the court would, among other things, keep the legislature within the limits assigned to their authority, so that the Congress wouldn't go off and try to assert powers that they don't have. He says the interpretation of laws is the proper and peculiar province of the courts. A constitution is, in fact, and must be regarded as fundamental law. Here's another very important point. The Constitution is kind of a higher law, primarily because of the way it was ratified. It's a supermajority, 2/3 to propose, 3/4 to ratify. So this is not just every run-of-the-mill statute, and this is one of the reasons why, when we get to Marbury versus Madison, that judicial review was exercised for the first time, because John Marshall, the first Supreme Court justice, is going to say, "Hey, you can't change the Constitution just through a simple statute." Okay, it says here that it therefore belongs to them, the court, to ascertain the Constitution's meaning, as well as the meaning of any particular act proceeding from the legislative body. If there should happen to be an irreconcilable variance between the two, meaning if you got this higher law Constitution and you got a statute made by the Congress or an executive order made by the president, that doesn't rise to the level of the Constitution. And so in some ways, it's the people acting through these constitutional processes that are supermajority driven. It's the people's will, in other words, that trumps the legislative assembly. Okay? And so if there's a difference between the law passed by the representatives and the higher law of the Constitution, well, which one should prevail? Hamilton would say it's by logic, it would have to be the Constitution. Not because the court is more powerful than Congress, it's because the Constitution is more powerful than any one branch of government. Now, the problem with that theory, right away, if some of you are thinking, thoughtfully here, is that Well, is there an opportunity sometimes for the court to take that power and abuse it, right? To say, oh well, I'm just keeping the Constitution higher than the court. I mean, by a statute, but maybe what they're doing is trying to make their own law because they don't like the one that was passed by Congress or a state legislature. More on that in a moment. But again, from Hamilton's perspective, it's not the court uh, muscling the Congress, it's the Constitution muscling both. The Constitution, therefore, ought to be preferred to the statute, the intention of the people through the constitutional process to the intention of their agents. And then he goes on to explain what I just was saying. Nor does this conclusion mean a superiority of the judiciary to the legislative power. It only supposes that the power of the people is superior to both, and that where the will of the legislature declared in its statutes stands in opposition to that of the people declared in the Constitution, the judges ought to be governed by the latter rather than the former. The fundamental law of the Constitution rather than a statute that is not fundamental. So that's Hamilton, okay? And I wanted to take a little time to talk about that because it really is important to kind of provide legitimacy to the court. Because the last kind of introductory remark I wanted to make in this whole issue of whether the court is power and how powerful it is that a critique of the court today is that it's not just preferring the Constitution to Congress or the states. What it's doing is trumping the will of the majority and the consent of the governed by making rulings that are just their own opinions as opposed to really looking at what the meaning of the Constitution is. So here's a few questions just to keep in mind as we move through this. One, is the Supreme Court really a defender of minority rights in the way that both Hamilton and Madison wanted? That they worried about majority tyranny, and here were these unelected, wise men, and now women, of course, that would really have the independence, because they're removed from elections, to be able to make the hard decisions when the majority acting through the legislative process maybe passes a law that impinges upon fundamental rights and freedoms, particularly of those who are in a minority status, not just racial minorities, although that's a big part of this, obviously, because of our legacy of slavery, but any kind of minority that has rights that ought to be defended regardless of whether a majority of 50% plus one want to take them away. So that's the ideal, right? So is the court acting that way? Or is it acting like a roving constitutional convention, changing the words, taking the due process clause, for example, and inventing a right to an abortion? That would be an example maybe of a roving constitutional convention, trying to find different or new rights, like the rights to privacy, for example, or the right, or how about the right to health care, or the right to any number of sort of new economic rights that you might, a right to housing, a right to education, okay? Or is it really like a super legislature nullifying the consent of the governed? So that's kind of the broad framework that I want to kind of discuss, the judiciary, because it is an awesome power, and in the American context, it's a nice feeling to have, actually, when it works, when it works according to the design, to have that kind of sober second look. So, take, for example, let's say to try to deal with this coronavirus, Congress passes law saying that it has the authority to basically order a quarantine of the entire country. And people are like, well, maybe we should be quarantined, but according to the Constitution, I don't find that power in Article 1, Section 8. I don't find it in Article 2 anywhere, like some kind of dictatorial power granted the presidency. And actually, it's a reserved power of the states under its police powers. And what are states doing? They are issuing quarantine orders, aren't they? They're closing schools like ours and all of the rest. But because of the federal nature of of our system, those powers are reserved not to the federal government, but to state and local authorities. But so if that occurs, even though it might be a quote unquote good idea, is that actually a legitimate power of the court to render and to allow that to occur just because they want to try to deal with a crisis at hand? So that would be an example of what we're talking about here. Oftentimes, it's not a question of a government doing a bad thing. It's whether the government is doing something that do they have the legitimate authority in the first place to do it? All right, so that's the first topic. The second topic, let's talk about the nature of the establishment of judicial review. I actually included on the Google form a little documentary. I think it's about 8 minutes long that actually does a really good job of describing what judicial review is. I read Federalist 78. I won't bother you more with that, but that's kind of the theoretical basis of judicial review. But it is an implied power. And there were founding fathers like Jefferson, for example. He was not at the Constitutional Convention, but he would argue that it's not just the exclusive province of the court to interpret the Constitution. And there, I'm kind of with him. I mean, you think about Congress, the presidency, state judges. What do? They all swear an oath on the Bible to what? To uphold and defend the Constitution of the United States. So it's not to say that the court doesn't interpret the Constitution, but it also means that the other branches of government ought to be able to interpret the Constitution as well. Imagine a Congress passing a law, and boy, I think they do it these days, that they know is unconstitutional, but they want to do it anyway because they think it's good politics, or they really want to do it, and that's again the difference between a republic, a nation of laws, versus a demagoguery or a tyranny, which is a nation of men and women just doing what they want to do, regardless of doing things arbitrarily instead of doing it according to the rules of the game. It's like playing a baseball game and deciding in the fifth inning that it's now going to be 4 outs and not 3. That kind of thing. So let's talk about Marbury versus Madison right now. Now, I in the interest of time, I don't want to go through too much of the nitty gritty here. There's actually a text that I have included in the document section of RenWeb that you can kind of read a little bit more of the details of the case. But here are the broad parameters. This occurs in I think the case was brought in 1802. Here's the background story. So, but in 1800, you had a very important election. It was one of the examples 4 or 5 times in America's history where nobody got a majority of the Electoral College, and it was thrown into the House of Representatives. And so the House was trying to decide between Thomas Jefferson and Aaron Burr. Burr was thought to have been the vice presidential candidate, but then they were tied in the Electoral College. This is we get the 12th Amendment out of this, right? Because now you're going to run as a team ticket with the president and the vice president. Anyway, this is a very, very dramatic election, and it's the first time where you have a switch in power from the Federalists to the Jeffersonian Republicans. And John Adams is president, and Jefferson doesn't take control until March, and actually it's not really determined whether he wins until I think February. So there's a lot of uneasiness and uncertainty surrounding this whole period of time. And one of the things that John Adams wants to do is he wants to put more people on the federal bench to make sure that the federal courts are staffed with Federalists that are going to interpret the Constitution in the way that he wants, as opposed to maybe how Jefferson wants it. So he appoints a bunch of new federal judges that were created by the Congress. This new Judiciary Act had created some new federal courts and judgeships along with that. They were those judgeships were filled by loyal Federalists. One of them, actually, there was actually a vacancy on the U.S. Supreme Court, and the new Chief Justice becomes John Marshall. And John Marshall was a Virginia politician. He was a distant cousin of Thomas Jefferson, but he is not a Jeffersonian. He is a Federalist, an advocate of strong national power as opposed to state power. More on Marshall in a moment. So Marshall gets the job, but before he was the Chief Justice, he was the Secretary of State under Adams. And so it was his job to actually fill the vacancies of these federal courts. And so he does. But there were a few of these commissions, basically orders by the Secretary of State, which was in this case Marshall, and some of them didn't get executed before the transition of power. One of these guys was a guy by the name of William Marbury, and he was given a post of kind of like a Justice of the Peace for the District of Columbia. Well, one of the provisions that was in this new statute was the ability of people like Marbury, if they had a problem with their commission, was to sue and to have a case directly heard by the U.S. Supreme Court in its original jurisdiction. And if you remember when we were dealing with the Constitution in Article 3, there's a difference between original and appellate jurisdiction. Talk about that in the second session. Well, anyway, to make a long story short, Marbury sues in the U.S. Supreme Court and says, look, I want my job. And so here's the problem for Marshall. Marshall is now he's Chief Justice of the Supreme Court. At that point, there were 6 judges on the court itself. Most of them were Federalists. And they don't want this Marbury, who's a Jeffersonian, they want Marbury to get his commission because he's a Federalist. Well, the new Secretary of State under Jefferson is none other than James Madison. And of course, Madison will later become president after Jefferson's 2 terms. Well, Jefferson directs Madison not to fulfill the commission. And so poor Bill Marbury doesn't have a job. So he sues in court saying, I want my job. And so one way that Marshall could have dealt with this issue was just to force Madison to say, look, the court rules that Marbury has, he has a legal claim to that job because he was appointed to it. Now, but remember who enforces Supreme Court decisions? It is the president. And who's the president? Jefferson. Who's the Secretary of State? Madison. They don't want to give this job to him. So what would Jefferson do? Probably not fulfill the appointment. And so then people like Marshall will and the Federalists would be out a judge. So this is where one of the questions in the Google form is summarize the facts in the ruling of the famous case Marbury versus Madison. Why might you say that John Marshall lost the battle but won the war? Well, here's how it happened. So he's not going to give. He says that, you know what? No, you can't. It's basically too late. But here's what he says in addition to that the statute that allowed Marbury in the first place to hear his case in the Supreme Court under its original jurisdiction was actually unconstitutional. And the reason being is that the statute, remember what Hamilton was saying, that the statute should not be preferred to the Constitution? Well, what does the Constitution say? It's the Constitution that determines what the original jurisdiction of the court is. And if you want to change the original jurisdiction of the court, what would you need to do? You would need to propose a constitutional amendment, 2/3 of Congress, and then have the states, 3/4 of them, to ratify it. Had that happened? Marshall says, of course it didn't happen. It was a statute that had actually gone beyond the constitutional authority of Congress. So the Jeffersonians did not like this whole idea of judicial review in the first place. They found it elitist. They found it something that was not pro-majoritarianism, pro-democracy. And so they didn't want to give the court the ability to do this. However, so what Marshall does is that even though he loses, Marbury does not get the commission and does not get the judgeship, what the federal courts get in exchange for that is the power of judicial review. And that is a very, very interesting political point. And this also points out that the court has always been a political body. And anybody who doesn't think that is kidding themselves. Okay, so that's the case. It's a very important case. Now, that is an example, the first example where the federal courts struck down a law made by its other co-equal branch of the federal government, in this case Congress, and of course the president signs any statute, any bill that becomes a law. So that's the first example of that happening in America's history. Now, do you know when that's what's 1803 is Marbury versus Madison. Do you know when the second time that occurs where the federal courts strike down a federal law? It's not until Dred Scott versus Sanford in 1857. And for those seniors who took American history last year, you know what a controversial decision Dred Scott was. We'll talk about that actually in a moment. But the point is that that Supreme Court case that struck down the Missouri Compromise and basically said that Congress couldn't regulate slavery in the territories. Now, that was not a wise decision. And a lot of people believe that it's a decision that actually was kind of the straw that broke the camel's back that brought us to the United States Civil War. So you can see, Marshall and Marbury, everyone kind of cheers that as not only a kind of clever political ploy on the part of Marshall, but it's asserting a power that most people would assume is a good thing for the court to have, which is to be able to tell Congress or the president or states when they pass laws that are contrary to the Constitution, that the court has the power to point that out. Again, the court not being more powerful than Congress in this instance, but the people enunciated through the Constitution is more powerful than any one branch of government. Okay, so you see that the second time not so good, and so remember our original position or original theme about whether this power of judicial review, why is it controversial and why is it legitimate or not? All right, so the third topic, and this is going to be, how much time do I have left? I got about 13, 14 minutes. This is a very, very quick history of the Supreme Court. And some of these cases we're actually going to revisit later in the course, so that there's really, we've got some time to go into more of the details on these, but you're going to need to know what are some of these landmark cases that I'm going to be talking about here. So you've got these different historical eras of the court. And just because of just the way things have broken down, a lot of these eras are signified by the Chief Justice that runs the court during the time. So we've just mentioned one, right? John Marshall. And so you have the Marshall Court era that really dominated the early part of the 19th century, really from 1800 to about mid 1820s. I think Marshall dies in the late 1820s. So that era, not only do you have Marbury versus Madison, but you have two other very important decisions, among many, but I just picked two. McCulloch versus Maryland, that is a case that dealt with the necessary and proper clause of Article 1, Section 8, and the constitutionality of the National Bank. Hamilton's Bank had been implemented during Washington's administration. It had expired, and they were trying to recharter it, and the state of Maryland was taxing the Bank of the United States, one of the branches of the Bank of the United States. Today it would be like the state of Maryland taxing a bank of the Federal Reserve Board. And so the Bank of the United States sued the state of Maryland. And what ended up happening was that Marshall rules he takes a Hamiltonian broad construction position on the necessary and proper clause. And so he says here in McCulloch, let the end be legitimate, let it be within the scope of the Constitution, and all means which are appropriate, which are plainly adapted to that end, which are not prohibited but consist with the letter and spirit of the Constitution, are constitutional. So this is kind of what we call a rational relations test, but again, that's a very broad kind of broad latitude given to the federal government in McCulloch versus Maryland. So Again, that's that federalist, strong national government bent of Marshall. The other case is Gibbons versus Ogden, and this has to do with whether Congress's power to regulate commerce excludes states' ability to regulate commerce. And so this has to do with, is the power to regulate commerce an exclusive or a power that is shared with the states? Just like the taxing power, just because Congress has the power to tax doesn't mean the states don't. But in the case of regulating commerce, the Supreme Court ruled that it was an exclusive power. And here's Marshall again. He says that this has to do with Robert Fulton's steamboat and whether the state of New York could grant a monopoly on for this steamboat company up and down the Hudson River, even though the Hudson River crosses state lines. In this case, Marshall rules that the state of New York cannot create this monopoly because it was actually a regulation of interstate trade, which is an exclusive power of Congress. And again, this is where sometimes the words and phrases of the Constitution beg for interpretation. It doesn't say that the power to regulate commerce is an exclusive power of Congress, but in this case, Marshall says it is. However, he does say that there are limits to this, and this is, I think, important for later on. He says, the enumeration of powers in the Constitution presupposes something not enumerated, and that something, if we regard the language of the subject of the sentence, must be the exclusive internal commerce of a state, meaning that Congress has the power to regulate commerce among the several states when it crosses a state border. But wonder if something is shipped within a state and doesn't cross a state line. What would logically be the case there? According to Marshall, that means that's a state matter, not a federal matter. And this issue actually, when we get to another era of the Supreme Court in a second, in the late 19th century, that's a very, very important distinction. So that's McCulloch versus Maryland and Gibbons versus Ogden. Now the next era of the Supreme Court is the Taney Court. And this is what we call the antebellum period. This is the period up into the Civil War. Two very important cases there. Barron versus Baltimore. I think I had mentioned that before we were closed. That was the case that the court ruled that the Bill of Rights only checks the power of the national government, and any limits on state power, you'd have to go to your state Bill of Rights. So this idea that, let's say a provision of the U.S. Bill of Rights and later after the Civil War with the Due Process Clause and the Equal Protection Clause, the precedent in Barron versus Baltimore would say that that only checks the power of the federal government. Now, in the case of the 14th Amendment, it does say no state shall, so that's a little bit different circumstance. But anyway, that's Barron versus Baltimore, and then the aforementioned Dred Scott case. This is dealing with the ability of Congress to regulate slavery. And here, what Taney does, he's from Maryland, he says that the Fifth Amendment's due process clause protecting property rights, and of course, what were slaves according to this notion? They were property, that trumped Article 4, which says that the Congress does have the power to regulate the territories. And this actually ends up, it was an issue with Missouri, and after that, there's actually a border war between Missouri and Kansas, and it really precipitates the beginning of the Civil War. So those are some big issues during the Taney Court, and an example where judicial review actually backfires, I think, on the process. After the Civil War, the post-Civil War court, you had a couple of big issues that the court is dealing with. One, civil rights. You can imagine there were a number of federal civil rights bills that were passed, but when it came to the court enforcing them, there was a case in Tennessee, Plessy versus Ferguson, where the states were actually regulating. This was a case dealing with railroads where you have a white car and a black car. And the question was, can the states regulate in that area to kind of basically say separate but equal. And the Supreme Court upheld separate but equal in the case of Plessy versus Ferguson, allowing the state of Tennessee to say that it was okay to have separate rail cars according to the color of your skin, which a lot of people believe was unconstitutional according to the 14th Amendment's Equal Protection Clause. The other big issue in the late 19th century was with the Industrial Revolution. What is the distinction or the difference between trading something, trading a product, engaging in commerce, and manufacturing or producing a product? And so this is the whole distinction between interstate and intrastate, and also the difference between production and distribution, or manufacturing and trade. And so in the U.S. versus Knight case, it's another kind of landmark case. The Supreme Court ruled that it was actually not a legitimate authority. The new Interstate Commerce Act, which was regulating how sugar was being processed in the state of Louisiana, that was a violation of the Commerce Clause, that actually manufacturing is not something that Congress can regulate, only the states could. Okay? Now, when you get to the progressive era, this is the early part of the 20th century, you have even more of these kinds of arguments. It has to do with states' rights, but it also has to do with economic liberty and how far the governments, both at the national level and the state level, can regulate aspects of the economy. And so in Lochner versus the United States, the state of New York had passed laws regulating the wages and the working conditions of bakeries. It doesn't sound like all that much, but bakeries were actually kind of dangerous places to work. A lot of dust and a lot of health problems actually were there, and so the states were arguing that they have the power under the police powers to regulate for the health and safety of workers. Well, what the court found in the Due Process Clause, and this is the first example where you see substantive due process, they said that there was a liberty of contract under the 14th Amendment Due Process Clause, that states could not basically regulate for safety and health because of the rights of a liberty of contract. They really kind of just created it out of whole cloth. And it struck down the New York law. All right. At the same time, they carried forth this distinction at the federal level between production and distribution. So there was a big outcry in the progressive era to regulate child labor. And so Congress passed a law saying that if you were a company making something, that you couldn't use child labor, if that you were going to then take that and then ship it across state lines. So it was a real distinction between, can you have labor laws at the national level? And the court struck it down, again, affirming this distinction between manufacturing and commerce. Then you get the New Deal court. So this is during the 1930s and 1940s. Franklin Delano Roosevelt, of course, he was elected 4 times, and he passed all sorts of economic legislation to try to stimulate the economy and regulate working conditions and all of the rest. And so in the early part of his New Deal, this court struck down a lot of his economic regulations in 5-4 decisions. And he actually then, after he's elected in 1936, he wants to pack the court with, expand the size of the court so he can get more people on the court that will then overturn some of these decisions. And then, so by 1938, the Congress rejects this idea of court packing, but by that time, the Supreme Court changes its mind. It's called the switch in time that saves 9. And so in 2 cases, National Labor Relations Board versus Jones. Sorry, my dog just barked. Come here. Come here. There we go. So in NLB versus Jones, it upheld the ability of Congress to regulate collective bargaining decisions, which was used to be just an exclusive state matter. And then in West Coast Hotel versus Parrish, it overturns Lochner versus New York and allows states to regulate working conditions of hotel workers. So that is the New Deal court. Two other ones I want to mention really quickly. And again, we're going to look at a lot of these decisions in more detail after we just talk about the court this week. We're going to do some actual constitutional law after this. But the Warren Court, very controversial era. This is in the 1950s and 1960s. Here, a real big issue is about judicial activism and the court striking down a number of state laws, particularly in criminal justice. So you have the Miranda case, where you get the precedent where now police have to read you your rights, which of course is not in the Constitution, but the Warren Court says that the Fifth Amendment and the Fourth Amendment require, and the Sixth Amendment, require you to do that. Escobedo is another case dealing with the right to counsel. Of course, the Constitution, the federal courts, the federal Constitution says that you have a right to counsel, but does the state have to pay for it? And again, think about Barron versus Baltimore. Does the U.S. Bill of Rights apply to state and local authority? Because they have their own bills of rights. Well, this is what we call the nationalization of the U.S. Bill of Rights and the incorporation doctrine. Again, more on that later. But basically, you get a whole host. You have the exclusionary rule, Mapp versus Ohio, where the federal courts are saying that police practices in terms of finding evidence and searching people's homes, that they basically tighten those whole procedures up. So it's a real example of the federal courts policing, in other words, the police at the state and local level. So there's a huge issues of federalism there. And you have the school prayer cases, Engel versus Vital and the Lemon versus Kurtzman. These cases deal with whether you can have school prayer in local and state schools, and the Supreme Court rules that school prayer is now unconstitutional because it interprets the Establishment Clause of the First Amendment. Again, First Amendment, Congress shall pass no law. Now they're saying state and local schools can't pass that law. So again, federalism is on the kind of being assaulted during the Warren Court. Finally, you get the Burger Court and the Rehnquist courts in the 1970s and 80s. The Burger Court, the big case there is Roe versus Wade. Another example where the federal courts are striking down state and local laws, in this case abortion statutes that criminalized abortion. You also had a case, Griswold versus Connecticut, establishing a right to privacy and striking down state laws banning the sale of contraception. And then finally, you get a little bit of a kind of a retaliation against some of these anti-state authority decisions under Rehnquist. Reagan and Bush had appointed judges that were more strict constructionists and originalists. We're going to talk about constitutional interpretation on Wednesday. And in a case called U.S. versus Lopez, the Congress had actually passed safe school legislation and gun-free school zones, arguing, get this connection here, that because the schools affect education, and education affects the economy, and the economy affects commerce, therefore, Congress can regulate schools because of its connection to commerce, okay? And the result is, finally, in a 5-4 decision, the court says, you know what? Education is not commerce, and actually the state of Texas had its own gun-free school zone. Congress didn't need to pass the statute, and so they struck it down. It was the first example since the New Deal and the New Deal court where the U.S. Supreme Court struck down Congress's legislation using the Commerce Clause as the authority. So that's a quick history of the Supreme Court. Again, you need to know Marshall Court, Taney Court, Post-Civil War Court, Progressive Era Court, New Deal Court, Warren Court, Berger and Rehnquist Court. All right, and then those lead cases: McCullough versus Maryland, Gibbons versus Ogden, Barron versus Baltimore, Dred Scott versus Sanford, Plessy versus Ferguson, U.S. versus Knight, Lochner versus U.S., Hammer versus Dagenhart, National Labor Relations versus Jones, West Coast Hotel versus Parrish, Brown versus Board of Education. I didn't talk about that one. That was a big one, right? Saying that separate was now not equal, and that overturned Plessy versus Ferguson. And then Roe v. Wade and U.S. versus Lopez under the Berger and Rehnquist courts. Again, I took a picture of the whiteboard, so that'll help you answer some of these questions. So, some of these other questions: describe at least 3 of the major historical eras of the court. Which one do you believe was most significant in terms of its impact on American politics? And then describe at least 3 landmark Supreme Court cases mentioned in the lecture. All right, so again, you don't have to go into great detail. Just tell me what the case was about, what it was, and what it was about. Okay, so that's it for now. I'm going to have another lecture here very shortly dealing with the judicial process. See you soon.